I am LaConya Murray. Thank you so much for joining me and being a part of the Beyond the Launch Facebook group. I'm excited to have you here. If you guys are new to me and the group, let me just tell you who I am. I'm brand attorney LaConya Murray, owner of Off the Mark IP Solutions, where I help clients throughout the United States own their genius by protecting their brands through trademarks, copyrights, and contracts. I'm excited for today. Today is Murray's Law, and what we typically try to do is come in once a week. We choose a question and come in once a week and we answer that question. I like to do it live because a lot of times when I answer the question, it brings dialogue and brings other questions that are related to that question. So yeah, that's what we're doing today. And just to give you a reminder that nothing that I'm saying today is legal advice. It is, however, legal information to help you make better decisions or talk so you can talk to a legal person, talk to an attorney with your questions and have better questions. So once you come in, say hey. If you're watching it on the replay, definitely let me know that you're watching it on the replay. And you guys excuse my face. I totally left all of my makeup at home, so I only really put on makeup when I get ready to do a video, and yeah, totally left it. But anywho, today's question is a great question by one of our new members, Kelly Jones, and her question is, do I need to file a trademark and a copyright? And what happens if I only file one? That is a great question. And I think that it's a good question because, again, when it comes to intellectual property, a lot of times people get them confused and they think that they're the same thing. They think that a trademark does the same thing as a copyright. And so what I get to do with this question is explain how they're not the same and how they actually offer different types of protection. So although trademarks and copyrights are both a form of intellectual property, they protect different things. And when it comes to whether you should file a trademark or a copyright, it really depends on what you're trying to protect. And so in this case, I'm going to go with a logo, because a logo is something, if it's an image-based logo, it's something that can possibly be protected by both a trademark as a brand identifier and a copyright as an original creative work. So we're going to talk about that. Let's say you have a logo for your business, and it is in fact a brand identifier, not just something that you're using as a design on a t-shirt or a mug or some other form of merchandise, because there is a difference. With trademarks, because trademarks protect brand identifiers, that logo, when someone sees that logo, they're going to have to be able to say, oh, I'd recognize that. It associates with, this product or this service. Think about the Nike swoosh. When we see that swoosh, we think of Nike and we think of their shoes and their apparel and all the other products that they offer. And so that's what your logo has to do. If it's not doing that, then and you just have it on a shirt, then it's not a logo, it's a design. So it's not going to qualify for trademark protection. But if it is in fact a brand identifier, then it qualifies for trademark protection. And if it's something that is creative as well, then it can also qualify for copyright protection. And the question is, do you have to file for both? No, you do not. You can choose to do one or the other. I always advise my clients, if you have something that qualifies for both protection, to do both, simply because it gives you double protection. With trademarks, remember, your protection is limited to how you use the mark, meaning that if you are a car manufacturer. If you are a car manufacturer and you have a logo and someone is a beautician and they're using that same or similar logo, there's not going to be a likelihood of confusion, because if I'm coming to get my hair done, I don't think that you are actually making cars. So for that reason, I would be able to use that same or similar logo as a beautician, even though you're using it as a car manufacturer. However, if you have a logo and it's also creative and protected by copyrights protect that work, that original work, no matter how it's used. So it doesn't matter if you're a car manufacturer or a beautician or whatever. That design itself is protected. But unlike the trademarks, it's not going to protect similar. So if someone creates something that's similar to your logo, it's not going to protect it unless what they actually created was a derivative of that logo. And what I mean by derivative is they actually took your logo and they just changed it. They made changes to it. That's what a derivative is. And so, for instance, what would that be? A derivative of a logo right? If you have it like graphic, a photograph of that logo will be a derivative. Another example, just so you can have a better understanding of what I mean, is someone writes a book and that book is turned into a screenplay, right? Something that they make changes to how it is produced. So that's what I mean by that. So if you have a logo and it's protected by trademarks and copyrights, if someone is infringing on your trademark, then you can have a claim for trademarks, which has one set of damages. If someone is infringing on your copyright, you can have a claim for copyright damages, and that is its own set of damages. And if you have both, then you can file for both, and now you get both damages. So that is the answer to whether or not you should file. If you need to file one or the other, I always advise, if it can be protected by trademarks and it can be protected by copyrights, to go ahead and to do that. The thing you need to know is that trademarks are good for as long as you use that mark. So as long as you're using that mark to identify your good or a service, boom, you're great. With copyrights, they do expire 70 years after the death of the owner, or 120 years if it's a corporation. So there can be some issue with that mark or that design falling into public domain and anybody being able to use it. And if you only have a copyright, now your brand is not as protected as it could be because you don't have a trademark for it. And then the next question was, what if I only file one? If you only file one, you only have that protection that the one that you filed offers, meaning that if you decide to protect that logo through copyright registration because it's cheaper, and someone is infringing on your brand with that logo, then you only be able to file a copyright claim, not a trademark claim. And depending on how they're infringing, maybe they're not making a derivative, maybe they just have something that was unique to them, but it is similar to what you created. And so with copyrights, they don't protect, let's see, how can I say this? They don't protect like the similar in the same way that trademarks do. Meaning that if someone came up with their own original idea for a logo and it was similar to yours, that doesn't mean that they copied it if they weren't influenced by yours. Meaning if they never seen it anywhere and they just came up with something on their own, but it kind of similar to yours, that doesn't mean that they copied yours. With trademarks, on the other hand, if someone came up with something unique that was similar to yours, it doesn't matter if they were influenced by you or not. It just matters that there's a likelihood of confusion in the market and that person can't use their mark. So there's a lot of different things that you have to consider when you're trying to decide whether or not you want to register your trademark or your copyright. And I hope that answer was helpful for you, Kelly. I know you're going to be catching the replay. Listen, if you have not already taken the Own Your Genius Challenge, go ahead, do so. It's a free 5-day challenge where you can learn more about trademarks, copyrights, patents, and trade secrets, all of the intellectual property, right? And so that is available. And yeah, that's what I have for you today. So until next time, I want you to keep growing your business and owning your genius. All right? Take care.